I always hit that hard. Calling the meeting to order of the Standing Committee on International Trade. We are doing a study on the subject matter of Bill C-4, an act to implement the agreement between Canada, the United States of America, and the United Mexican States. The witnesses that are appearing before us, before committee, which I very much appreciate the short notice and the fact that you're here with us today. From Global Affairs Canada, Steve Earle, Chief Negotiator and Assistant Deputy Minister, Trade Policy and Negotiations. Welcome. Martin Thornell, Senior Advisor, Tariff and Goods Market Access. Aaron Fowler, Chief Agricultural Negotiator and Director General, Agriculture and Agri-Food Canada. And Stephanie Chandler, Senior Policy Advisor, Trade Policy and Negotiations. And from Environment and Climate Change Canada, Rena Young, Manager, Trade and Environment International Affairs Branch. Mr. Earle, I'll turn the floor over to you for your opening comments.
Madam Chair?
Oh, I'm sorry. Excuse me. Mr. Carey?
I just have a request. We're getting started about 15 minutes later. The witnesses have been here, and if required, I was just wondering if we could ask the witnesses if they could stay an extra 15 minutes, if that's appropriate with the committee.
If the witness would be able to stay 15 minutes later today, we would very much appreciate it. All right? Okay. Okay.
Happy to do so.
Please, the floor is yours.
Okay, thank you, Madam Chair. First of all, thank you for the invitation to appear before the committee today. We look forward to answering questions regarding the outcomes of the Canada-U.S.-Mexico Agreement, or CUSMA, following my opening remarks. The signature of the CUSMA on November 30th, 2018 followed 13 months of intensive negotiations that brought together a broad range of officials and stakeholders with a strong partnership between federal and provincial officials. That agreement achieved several key outcomes that served to reinforce the integrity of the North American market, preserve Canada's market access into the U.S. and Mexico, and modernize the agreement's provisions to reflect our modern economy and the evolution of the North American partnership. On December 10th, 2019, following several months of intensive engagement with our U.S. and Mexican counterparts, the three NAFTA parties signed a protocol of amendment to modify certain outcomes in the original agreement related to the specific issues of state-to-state dispute settlement, labor, environment, intellectual property, and automotive rules of origin. These modifications were largely the result of domestic discussions in the U.S. However, Canada was closely involved and engaged in substantive negotiations to ensure that any modifications aligned with Canadian interests. Throughout the negotiations, Canadian businesses, business associations, labor unions, civil society, and Indigenous groups were also closely consulted and contributed heavily to the final result. To help better inform Canadians of the outcomes, documents have been made available on the Global Affairs website, including the text of the agreement itself, the amending protocol reached on December 10th, a summary of the overall outcomes, and summaries of all chapters in the agreement. I would want to start by recalling that the NAFTA modernization discussions were unique. This was the first large-scale renegotiation of any of Canada's free trade agreements. Normally, free trade agreement parties are looking to liberalize trade. In this process, the stated goal of the U.S. at the outset was to rebalance the agreement. The President of the U.S. had also repeatedly threatened to withdraw from NAFTA if a satisfactory outcome could not be reached. The opening U.S. negotiating positions were, I think to put it mildly, unconventional. These included a proposed 50% U.S. domestic content requirement on autos, the complete dismantlement of supply management, elimination of the NAFTA Chapter 19 binational panel dispute settlement mechanism for anti-dumping and countervailing duties, removal of the cultural exception, a state-to-state dispute settlement mechanism that would have rendered the agreement completely unenforceable, a government procurement chapter that would have taken away NAFTA market access, leaving Canada worse off than all of the other U.S. other FTA partners, and a 5-year automatic termination of the agreement, known as the Sunset Clause. The U.S. administration took the unprecedented step of imposing tariffs on imports of Canadian steel and aluminum on purported national security grounds, but with no legitimate justification that was provided. The U.S. administration had also launched an investigation that could lead to the same for autos and auto parts. In the face of this situation, Canada undertook broad and extensive consultations with Canadians on objectives for the NAFTA modernization process. Based on the views we heard and our internal trade policy expertise, Canada set out a number of key objectives which can broadly be categorized into the following overarching areas. First of all, we wanted to preserve the important NAFTA provisions and market access that we have into the U.S. and into Mexico. We wanted to modernize and improve the agreement where possible, and we wanted to reinforce the security and stability of market access into the U.S. and Mexico for Canadian business. In her August 14th, 2017 speech launching the NAFTA talks, Minister Freeland set out 6 objectives. The first was to modernize NAFTA. The second was to make the agreement more progressive in the areas of labor, environment, gender, and Indigenous peoples, as well as removing investor-state dispute settlement. Also to cut red tape and harmonize regulations. Freer market for government procurement. Also establish a freer movement of professionals. And finally, to maintain items of special national interest, such as supply management, the cultural exception, and dispute settlement for anti-dumping and countervailing duties. In terms of the outcomes, with respect to preserving NAFTA, Canada maintained the CUSMA outcome that preserved important elements of the NAFTA, including NAFTA tariff outcomes. In other words, we ensured continued duty-free access into the U.S. and Mexican markets for originating goods. We preserved the binational panel dispute settlement mechanism for anti-dumping and countervailing duty matters, which is a key component of the overall goods market access package of the NAFTA and of the original Canada-U.S. Free Trade Agreement. We preserved Canada's preferential access to the U.S. under the temporary entry for business persons chapter. We preserved the predictability and security of access for services, suppliers, and investors. We preserved the cultural exception. And we preserved state-to-state dispute settlement, and in fact improved upon that mechanism, including through the Protocol of Amendment, to ensure that Canada can rely on an efficient and effective mechanism to resolve disputes with the U.S. and with Mexico. In the area of autos, changes were made to the rules of origin regime to encourage the use of more inputs from Canada, in particular by increasing the regional value content requirements for autos and auto parts, and removing incentives to produce in low-cost jurisdictions. Together with the quota exemption from potential U.S. Section 232 tariffs on autos and auto parts, secured as part of the final outcome, these new automotive rules of origin will incentivize production and sourcing in North America and represent important outcomes for both our steel and aluminum sectors. With respect to modernizing the NAFTA outcome, we have included modernized disciplines for trade in goods and agriculture, including with respect to customs administration and procedures, technical barriers to trade, and sanitary and phytosanitary measures, as well as a new chapter on good regulatory practices that encourages cooperation and protects the government's right to regulate in the public interest, including for health and safety. Commitments on trade facilitation and customs procedures have been modernized for the 21st century to better facilitate cross-border trade, including through the use of electronic processes, which will reduce red tape for exporters and save them money. We have new and modernized disciplines on technical barriers to trade in key sectors designed to minimize obstacles for Canadians doing business in the U.S., in Mexico, while preserving Canada's ability to regulate in the public interest. The agreement also includes modernized obligations for cross-border trade in services and investment, including financial services, telecommunications, and a new digital trade chapter. On labor and environment, we have made important steps forward by concluding ambitious chapters that are fully incorporated into the agreement and are subject to dispute settlement. These obligations will help ensure that parties maintain high standards for labor and the environment, and that domestic laws will not be deviated from as a means to gain an unfair trading advantage. The outcome also includes a special enforcement mechanism that will provide Canada with an enhanced process to ensure the effective implementation of labor reforms in Mexico, specifically related to freedom of association and collective bargaining. Finally, the outcomes advance Canada's interest towards inclusive trade, including through greater integration of the gender perspective and better reflecting the interests of Indigenous peoples. With respect to some other outcomes, in the context of the overall outcome, Canada did make some incremental moves in relation to the U.S. objectives, specifically in the areas of supply management and intellectual property. On supply management sectors, we should recall that the U.S. made an explicit and public demand for the complete dismantlement of the supply management system. But in the end, we preserved the three key pillars of supply management, including production controls, import controls, and price controls, and granted only minimal access to the U.S. The government has also been clear in its commitment to provide full and fair compensation to farmers in this regard. On intellectual property, obligations cover a broad set of areas, including copyright and related rights, trademarks, geographical indications, industrial designs, patents, pharmaceutical, intellectual property provisions, data protection for agricultural chemical products, trade secrets, and intellectual property rights enforcement. Certain outcomes will require changes to Canada's current intellectual property legal and policy framework in certain areas, such as intellectual property rights enforcement to provide ex officio border authority for suspected counterfeit or pirated goods in transit, as well as criminal offenses for the unauthorized and willful misappropriation of trade secrets. In other areas, Canada has transition periods to implement its commitments. For instance, on the obligation to provide a copyright term of life of the author plus 70 years, Canada currently provides a term of life plus 50 and has a 2.5-year transition period to implement this obligation following the entry into force of the agreement. Under the amending protocol, the parties agreed to remove the obligation to provide 10 years of data protection for biologic drugs, meaning that Canada does not need to change its existing regime in this area, which provides a protection term of 8 years of data protection. I'll just mention a couple of other notable outcomes. Faced with the U.S. demand for automatic termination every 5 years, Canada instead proposed a process that would lead to the regular review and modernization of the agreement, and we settled on a 16-year term with a formal review every 6 years, after any of which the agreement can be extended for another 16 years. We also addressed issues of concern to civil society, including with respect to the removal of the energy proportionality clause and introducing new obligations on privacy and access to information and an exception for Indigenous rights. We no longer have a trilateral investor-state dispute settlement for Canada. The U.S. and Mexico maintained only a very narrow set of investor-state dispute settlement obligations. And investor-state dispute settlement under the original or existing NAFTA will have a 3-year transition period for investments made under that original NAFTA. There is no government procurement chapter between Canada and the other parties. Canada maintains its access to the U.S. under the World Trade Organization's Agreement on Government Procurement, which was significantly more ambitious than the original NAFTA chapter. And we retain our access to Mexico via the Comprehensive and Progressive Agreement for Trans-Pacific Partnership. We were unwilling to accept a NAFTA minus outcome on government procurement, which was all that was offered by the U.S. So in closing, I would like to underline that our objectives for these negotiations were informed by Canadian priorities and interests, close engagement and consultations with provinces and territories, as well as a wide range of stakeholders, and the collective knowledge and experience of trade policy and sector experts across the government. The views and information provided by stakeholders, including industry, labor, civil society, and Indigenous peoples, and others, informed all of Canada's negotiating positions. The strong support for the new agreement expressed by industry and key business associations is clear evidence that we listened carefully to their views and advocated strongly for their interests. This concludes my opening remarks. We would be pleased to answer any questions you may have regarding the agreement. And thank you very much, Mr. Chair. Madam Chair.
Thank you very much, Mr. Vail, and congratulations to you and the team on some excellent negotiating on behalf of all Canadians. All right, we have Mr. Carey for 6 minutes.
Thank you very much, Madam Chair. And I wanted to just start off today by thanking the officials for being here, particularly Mr. Verhoeven. I think your experience and knowledge is very much respected around the table, so thank you for being here today. Off the top, I just wanted to address some things recently. On December 12th, we met and we asked the government to provide important documents so members of Parliament in this committee could fulfill our democratic obligation, basically, to review this very important agreement. This included economic impact studies, and we've watched the process in the United States, I think everybody around the table, and there is some concern if something unexpected happens and we're reviewing it and there's an issue that needs to be addressed. I have a process question for you. If Canada decides to amend the agreement, does it have to be sent to the United States and Mexico to be ratified?
Yes, if we are proposing to make some change in the agreement, which has already been agreed trilaterally between the three parties, we would certainly have to ensure that the U.S. and Mexico were on board and agreeable to those changes.
All right. See, the government is asking us to move forward quickly with this as soon as possible. I think everybody would like to see this done as best as we can. I was wondering, will the minister table the economic impact studies used to analyze the agreement and determine its effects on Canada? Will we be able to have those studies sooner than later, or what's the timeline for that?
It is certainly our hope that we will have the concluded economic assessment in the very near future. I'm expecting that I will see a revised draft sometime today. But I will caution that the economic assessment of the outcome of a negotiation such as this is a bit of a challenge to analyze, because we have an existing agreement, which is an NAFTA. We have this new agreement, which in many ways replicates outcomes of the NAFTA. So we have essentially free trade as it stands now. We're not looking at a lot of increased liberalization beyond what was in NAFTA. We were aiming to preserve it. So most of the changes that we made that we would characterize as improvements are going to be the facilitation measures that we took to streamline products going back and forth across the borders, what we've done on regulatory cooperation and technical barriers to trade. All of those are very difficult to quantify economically. So we do have a challenge in trying to develop an economic assessment that is going to provide a lot of value, because a quantitative economic assessment just doesn't have that much to work with, given that most of the trade is already free. And these other elements are very hard to quantify because there's no real numbers attached to them. It depends on how much cooperation and how far we can go in harmonizing different regulations and those kinds of issues. So we are working on it as quickly as we can. We do anticipate having it within the coming days, and we'll make it available to the committee and others. But I just wanted to highlight that this is not the same kind of economic assessment we would do with a brand new agreement.
Well, I understand that. I think members around the table, we're hearing not only, well, I guess from improvements with the deal, but sectors that may not feel that it's an improvement for their sectors. And I was just curious, when did the minister task you to produce this economic impact study?
Well, the economic impact study is something that is not done by my group, which is essentially the negotiators. It's done by the chief economist officer.
Do you know the date that she asked for the?
I'm afraid I don't know offhand. This is something that's been worked on as we were in regular contact with the chief economist's office as we went through the negotiations. Obviously, they can't go too far with their analysis until we have a final agreement, which they can then assess. We didn't really get that until December 10th with the modifications that were made. They've been working diligently since then to go through their economic analysis, and we're now at the point where we're very close to having a final outcome, and we will be providing it to the committee in the very near future.
Out of curiosity, has the minister made available to you any documents that you'd be able to table for us? We know we're starting this as quickly as we can. I know we're very anxious to look at any data that you have. Are you guys able to produce anything for us that we could take away today and start taking a look at it?
Well, I think we put quite a bit of information on the web. Certainly a detailed description of the outcomes, chapter by chapter. An overall assessment of the agreement. We've included some analysis sector by sector that I think is available. So certainly there's a lot of analysis that's available and has been published with respect to the implications of the agreement for sectors, for regions, for various areas, and an overall picture. What we don't have as of this point is that economic assessment that has not yet been quite finalized.
Thank you very much, Mr. Taylor. So your 6 minutes is up. Mr. Arya.
Thank you, Madam Chair. First of all, on my behalf, on behalf of the people of Nepean and indeed all Canadians, I would like to recognize and appreciate the hard work done by the negotiating team for a long period of time. I'm sure there's a lot of lessons learned, and I'm sure those lessons can be applied in future negotiations with other countries, other trading blocs. We are all elected officials wearing different political colors. However, even though we may differ on ideological source, but our end objective is the same. That is what is good for the Canadians, and you guys have achieved that. I am thankful for that. We all know that Canada is a trading nation. 60% of our GDP comes from trade, and we are rich today because of the natural resources, oil and gas, minerals, forestry products. But the world is going towards the knowledge-based economy. So I would like to know where this agreement stands in respect of where our economy is going in the next 5-10 years in the new digital age.
Okay, thank you for the question. I think that one of the core elements that we spent a lot of time focusing on during this negotiation was not to simply look at what's in the existing NAFTA and extrapolating some of that when it comes to traditional areas like goods, like services, like investment. But we wanted to modernize it by introducing elements that do not exist in the current NAFTA, including digital trade, including a much more of an emphasis on the economy of the future rather than the economy of the past, which is NAFTA, being 25 years old, is necessarily focused on. So we did spend a lot of time on that modernization, and digital trade was a key part of that. We do have a new digital trade chapter in this agreement that we did not have before. I think there are few chapters of this nature in any free trade agreement around the world. We have agreed not to discriminate against or impose any kind of customs duties on online digital products. That's something that's been out in the international discussions for some time, but we've locked that in. We have ensured cross-border flows of information, minimized data localization, and have been ensuring that we permit the necessary data protections that we feel need to be enshrined in an agreement in order for us to pursue these kinds of obligations.
Thank you. In your remarks, and obviously the new chapter on good regulatory practices, you mentioned that it encourages cooperation and protects the government's rights to regulate in public's interest. First look, it appears good for us that we can still regulate, we have the right to regulate, but I think it's a double-edged sword. Will it not give US the same rights to regulate this trade or agreement based on the public interest?
Well, yes, and I think that's essentially the way it should be. I think each country should have the right to regulate according to what its own population is looking for and demanding in terms of the kinds of regulatory framework that they want within that country. And the regulatory considerations do reflect, to some extent, the kind of culture and the way of thinking in each of these countries. I think that one of the issues we've encountered in recent years in negotiating free trade agreements is that there's a bit of a backlash against any kind of regulatory harmonization. Where it's possible and where it makes sense, then certainly I think we would advocate, and we have this in our agreements, that we should harmonize where we can to reduce any kind of barriers between getting into one of the other markets that we're involved in. But at the same time, you don't want to have your regulatory regime completely tied to that of another country, because you may have different interests, you may have different values, you may have different pursuits that you want to have the freedom to have your own ability to establish your regulations. So it's a bit of a challenge to ensure that where we have common views, we can eliminate barriers to trade because of regulatory matters. But where we have different views, we need to have the freedom to be able to still impose regulatory requirements where those are necessary.
A quick question on the intellectual property rights. We have made certain commitments that these provisions go beyond the current multilateral agreements. How much time do you have that we have to make sure that our multilateral agreements come in line with this, what has been agreed to?
Well, I think what we've discovered in recent years is that we've seen the difficulty of the multilateral effort to try to move forward on these types of issues. There has not been a sufficient amount of agreement to converge on elements on a multilateral basis that we could include in an agreement. Bilateral efforts have moved more quickly and are now more advanced than the multilateral efforts in trying to achieve those kind of regulatory understandings. We're working in both directions. We're trying to advance what we can on regulatory issues at the WTO, but is also in various other multilateral fora as well. But it's really a matter of the regulatory issues are advancing more quickly in bilateral agreements. We see this not only in the agreement we have with the U.S. and Mexico, but also in the agreement we have with the Europeans on regulatory issues. And it's a matter of making the right kinds of judgments about where we can move towards some kind of harmonization and where we need to ensure that we have sufficient freedom to develop our own regulatory requirements.
Savard Tremblay, 6 minutes. 6?
Thank you. Good afternoon, and thank you for being available. I know you already came to my office and explained to me different aspects of the treaty, and I'm grateful for that. I want to ask a few questions. We've talked a lot about aluminum on behalf of the Bloc Québécois. Is it true that with respect to steel, after 7 years, steel will have to be smelted and produced in Canada, but aluminum will not have the same protection? As we know, Mexico has no anti-dumping rules. So I'm talking about aluminum here and not steel. So will that apply?
In the most recent obligations taken on as of December 10th, that there will be a requirement on steel that after 7 years, there will be a requirement that auto manufacturers that are purchasing steel will have to ensure that it's melted and poured within North America. With respect to aluminum, that condition at this point does not yet exist, although we do have an obligation that after 10 years we will revisit that. At 10 years is not a hard line. In fact, we will be looking very closely at what kind of volumes of aluminum are coming into the North American market, particularly into Mexico. And if we start to see that there is a significantly increased amounts of aluminum coming into Mexico, then we will have an increasingly strong case to say that aluminum needs to be treated the same way as steel is treated. But I think part of this has been misunderstood, because the requirement that exists with the agreement when it comes into effect is that 70% of any purchases of steel and aluminum by manufacturers has to be of North American origin. But if you couple that with the 75% requirement for any vehicle to have regional value content, on top of that, 75% of the core parts, including engines, transmissions, bodies, various other elements, have to be of North American market. 40% of the value of the vehicle has to be produced in jurisdictions that have wage rates greater than $16 an hour U.S. When you take all the combination of those elements, you don't have that much scope to bring in a lot of foreign product. And I think that this is something that I think has been a bit misunderstood, because there are certain elements that, and Martin can add to this, but there are certain elements or products that aren't produced within North America. For the most part, the screens that we have in cars, not produced in North America. So when an auto manufacturer, or even an auto part manufacturer, is considering how much North American content they can make, they're pretty constrained. If they're looking at 75, has to be North American. They're obligated automatically for some products that aren't produced in North America to use up a good portion of that 25%. Our view is that they will have little choice but to buy aluminum from North American sources for the most part. So there's there's a large amount of pressure in order to do that. Plus, again, if we find that Mexico is importing aluminum slabs from China, other places, putting it into further processing and putting it into cars, that's all just building a case for us to say aluminum needs to be treated the same way as steel. Martin, did you want to add something?
Just a couple of things. I mean, I've said this on a few occasions. I mean, the NAFTA had the most stringent rules of origin for automobiles of any FTA in the world. And we have, in this agreement, made them significantly more stringent. And I think it's important to remember that, for example, on aluminum, Canadian automakers are using North American aluminum. American automakers, by and large, are using North American aluminum. Admittedly, there are some Mexican automakers who are using some non-originating aluminum, but their ability to do that is now going to be constrained. I think that's important. So we've now got these very restrictive rules of origin, I would say. And the point about the higher regional value content thresholds, I just want to maybe dig in a little bit to explain why that's relevant here. For example, if it's a cast aluminum part or a stamped part, these parts, a significant portion of their value is the metal content. So if you're casting a part from non-originating aluminum, you will not wind up with an originating part. You won't be able to satisfy these 75% regional value content thresholds in the case of, say, an engine part, or 70%, like in the case of, say, a significant portion of the value of a radiator is an aluminum core. You just won't meet that rule. And as Steve was mentioning, like a 75% threshold is tough when, certain electronics in a vehicle are certainly in the near term going to continue to be sourced from offshore. Like display screens are in fact the best example, I would say, of that. So I think this strengthening of the requirements across the board is pretty important, and I think it means that our aluminum sector, our steel makers, our auto parts companies who have been very successful at selling to Canadian and North American producers this creates an opportunity for them to do even more.
Sorry.
Yes, so
Is my time up?
6:57 actually. Mr. Blakey.
Those same steel and aluminum content requirements, I'm just wondering, can you tell us what, for cars that are produced in North America right now, what percentage of the steel and aluminum used in those cars is North American?
I can't tell you that.
Okay. So we can't say whether the 70% requirement is less than, equal to, or more than what is currently the case.
I'll tell you what I do know. Sorry, Steve. Should I?
Well, I would actually, if you don't mind, just because I have a number of questions, would you mind just tabling or sending to the committee in writing what you do know about that and what numbers that the department has?
The answer what I was gonna say is that we consulted with the companies throughout the process, and so the question we asked them is, if faced with this sort of requirement, does this, what does this mean for you? Does this mean that your vehicles will no longer be originating, will no longer qualify? And the answer, they told us, no, we can satisfy that requirement. Okay. So they're using North American steel and aluminum today because it's the nature of the... In fact,
they might be using more than what the guarantee is.
Indeed.
Okay.
And it's the nature of the industry, right? Like proximity. I
want to jump to dairy, and I want to ask, one of the things that we've heard concern about is the fact that there's an extreme limit on the export of milk protein concentrate and skim milk powder, infant formula, and the penalties for exceeding that are harsh and meant to keep Canadian producers out of the international market in a preventative way. It's not that they're necessarily a big force on the international market right now, but the export quotas would prevent them from expanding their business, not just into the U.S. and Mexico, but into other international markets as well. So the cap this year is 55,000 megatons. It'll be 35,000 megatons in the second year. Now, the dairy fiscal year is from August 1st to July 31st, and there's serious concern that if the deal is ratified before August 1st, that year two will begin on August 1st, which doesn't align with their production forecast for the coming year. Has the government made any provision to, I know in CITA, for instance, a large percentage of the agreement has been ratified and is being implemented, but the provisions on ISDS are being held back, which hasn't prevented the rest of the deal from going forward. Has the government made any provision for enacting the lion's share of this agreement, but holding back on dairy till August 1st in order to protect dairy producers at least in this year?
Thank you, Chair. Thank you for the question. It is a situation that we're well aware of, that the volumes that are provided within the export thresholds for the three products that you're talking about are to be administered on a dairy year basis. There is no provision in the agreement to prorate those in light of the entry into force date of the agreement. And so there is the possibility that if the agreement enters into force late in the dairy year, that Canadian exporters may not fully utilize the export volume that is provided within the threshold.
Now, passage of the ratification legislation in Parliament doesn't mean that the government has to implement the agreement immediately. It could any time after the legislation passes, but the Governor and Council could choose to delay implementation of the agreement, at least on paper. Is that accurate? Yes or no?
That's a question for you.
Yes, the government can decide when the implementation of the agreement will take place. I think that the provisions in the agreement are actually fairly clear, though, and I think you're familiar with this, that it would be the first day of the third month after the last party ratifies the agreement. So that definitive point would be when we actually ratify the agreement. Then it would be the first day of the third month after that.
So if the agreement were ratified after May 1st, then that would push us into the next dairy fiscal year.
It would be at the beginning of of August, yes.
Okay,
Yes.
thank you. I wanted to ask, I know there were media reports early on in the negotiation process for the new NAFTA that the government was committed to preserving the ISDS provisions in NAFTA. I'm wondering at what point in the negotiation the government decided to respond to American pressure to remove the ISDS provisions and no longer hold that as an objective in their negotiations.
Well, I think that this wasn't simply a matter of the U.S. wishing to eliminate investor-state dispute settlement across the board in NAFTA. What the U.S. was mainly concerned about was eliminating investor-state dispute settlement in relation to Mexico, because their view was that that actually provided an incentive for investors to invest in Mexico rather than in the U.S.
Okay.
Because
but Canada did publicly state at one point that it was a goal of theirs to preserve Chapter 11 in the NAFTA negotiations. Is that true?
I'm not sure that we ever explicitly stated that. We did have an interest in looking at investor-state dispute settlement in the context of this agreement because, as you probably know, there have been far more cases taken by U.S. investors against Canadian policies than any Canadian investors taking cases against the U.S. So in an environment where we have fairly sophisticated court systems on both sides, we didn't feel that we needed investor-state dispute settlement in relation to governing these issues between Canada and the U.S.
If I may, I just want to pursue...
Time is up.
Okay.
I was just allowing the witness to finish the testimony. Sorry. Okay, on for 5 minutes. Mr. Fast.
Well, thank you very much, Madam Chair, and welcome to the panel, especially Steve. The last time you and I were at this committee together, I think I was sitting over there right next to you, and we were defending CITA, or trying to defend CITA, right? Let me start by just asking a follow-up question on Mr. Kerry's concerns, and that is about the economic impact statement. We have asked Minister Freeland for that for months now. Obviously, we as a committee, certainly we on the opposition side, are not prepared to buy a pig in the poke. We want to know exactly what Canada is signing on to and the impact this agreement will have on our economy. And I note that the United States, back in April of last year, completed its own economic impact assessment, some 400 pages, telling Americans and their decision makers exactly what was in the agreement, the impact it would have on their economy. And it just baffles me why our government, by the way, I'm not pinning this to your shoulder, I'm saying this is the government's failure to deliver on something essential when we're dealing with the largest trade agreement Canada will ever be party to. And so I'm going to ask you to, first of all, pass on our profound disappointment to the minister about her failure to deliver on this right now. Can you, Steve, provide us with assurances that before final ratification takes place, before this committee process is finished, that we will have an economic impact assessment available to all of us MPs around this table?
I'm fairly confident that I can provide you with that assurance because we are very close to finishing, not our group, but the Chief Economist group, finishing that economic assessment. You mentioned the U.S. assessment that was done. We examined that closely when that came out, and it did come out some time ago, as you pointed out. But they assigned a particularly large amount of value to what they termed reduced policy uncertainty. That's not really something that can be measured quantitatively through an economic assessment, but it made a huge difference in the conclusion of their assessment. If you remove this notion of reduced policy uncertainty, which is fairly nebulous, the U.S. analysis actually projects a loss in relation to the NAFTA outcome, or the new NAFTA outcome. What we've been trying to do in our own analysis, and we've been talking to our economists as they've been conducting this, is to try to come up with something that we can defend credibly. And as I mentioned earlier too, given that this is a revisiting of an existing agreement, we already essentially have free trade. So significant new gains are not something that's likely to appear.
Okay. Maybe I can follow up on that because my time is short.
Sure.
You said in your comments this is all about preserving Canada's market access to the partner states, the U.S. and Mexico. I don't think that Donald Trump saw it that way.
Absolutely not.
He saw it as gaining new market access. And I've looked at the agreement. It looks like Canada, on issues of market access, it was Canada that conceded without any corresponding gains on market access. I know there's some improvements on how we deal with non-tariff barriers like sanitary and phytosanitary standards, but I don't see any real substantive new market access in Canada's favor, and yet the Americans certainly have new market access, especially in the area of chicken, dairy, eggs. I'm just wondering how we square that, because the government said this was going to be a win-win-win. Promised this was going to be a better deal than we had before. And quite frankly, by any standard that I've applied, this agreement is lesser. Yes, it preserves market access to the United States, our largest trading partner, but it's not a better agreement.
Well, I think that when you look at the issue of market access, what was negotiated is fairly limited. There were no real market access gains in the industrial sector. There were no real market access gains in fisheries sector. The only area where there were any significant market access improvements, and significant might be even a strong word in this respect, were with respect to protected products. So supply management for Canada, sugar and sugar-containing products, peanuts, margarine in the U.S. So while we did offer the U.S. increased access to our dairy, poultry, and egg markets to some degree under certain conditions, we also gained access to the U.S. dairy market. We gained access to the U.S. sugar-containing product market, peanut butter market, other various markets. But I might ask Aaron if he wants to elaborate on some of that.
Thank you very much. I'll keep it very brief. Yes, I would say the access may not look significant taken in the context of the overall agreement, but I can assure you it's quite significant to the sectors who stand to benefit. So if you look at sugar in particular, the United States will provide a new country-specific TRQ for Canada for 9,600 tons of refined sugar, 9,600 metric tons of sugar-containing products upon entry into force. That's in addition to the market access that we already enjoyed under the NAFTA for those products. The U.S. has agreed to eliminate its tariff on margarine over 5 years and to adjust the rule of origin so that it's easier for Canadian margarine manufacturers to access that market. They've also agreed to eliminate their tariff on peanut butter over 5 years and to eliminate their tariff on peanuts over 5 years. It's not a wide range of products, but there wasn't very much that wasn't already subject to tariff disciplines under the NAFTA.
Thank you very much. On to Mr. Sheehan for 5 minutes.
Thank you very much, Madam Chair. And since this is our first committee meeting, I just wanted to say that it's an honor having you before us at our first committee of this 43rd section. You presented before at the former trade committee meeting, and some of us that were a part of this past trade committee have heard about your great work, and some new folks are just hearing. I'm sure they're aware of it, your great work as well. So one of the things I wanted to touch on, Steve, was me. I'm from Sault Ste. Marie, steel town, and 60% of Algoma steel is exported to the United States. So when Donald Trump had put the 232 tariffs on steel and aluminum, well, 25% on steel and 10% on aluminum, there was great concern in my community and across this country. A lot of people didn't think he was going to do it, but he did it, and he used it on the grounds of national security. And I always have said, from my window, I literally look across at the United States, and I don't see any, gunboats in the St. Mary's River or any turrets. We have the longest undefended border. We have NORAD in North Bay, a shared defense. It was insulting for Canadians, I think, as well, that they used that tool at that time. And also, not only insulting, it was of great concern to people in Sault Ste. Marie. I'd walk into a Tim Horton Donuts, and the nervousness, not just on the steel workers' faces, but their spouses, their children, their parents. It was like really deep concern. And it hurt badly. So, I was proud of this Parliament coming together in this trade committee that went down to Washington, united, all parties, and looked square in the face of the American legislatures and said, we will not pass this until you lift those 232 tariffs on steel and aluminum. And I know there was many other committees went down. I was down with the industry committee. I co-chair the all-party steel committee, and we did the same thing. And that, I think, coupled with the dollar-for-dollar counter-punching we did above our weight, not only on steel and aluminum, but gherkins and sleeping bags and Jack Daniels, I think, caught their attention and hurt them back a bit. And as well, a lot of the changes that we did to strengthen our steel remedy system, anti-circumvention, scoping, the hiring of 40 new, Canadian service border workers specialized in forensics to do that. In your opinion, Steve, could you please explain to us how important it was and how maybe other areas of this great country came together to work against those 232 tariffs that were really, really hurting the steel and aluminum industry?
Well, yes. From my perspective, you've described that feeling very clearly. When the U.S. put those tariffs against Canada on steel and aluminum on national security grounds, when we have such a close alliance with the U.S. on defense issues and anything to do with national security, I think it's fair to say that we did feel that was a bit of an insult. We do not, in any measure, pose a security threat to the U.S., and in particular, we don't pose a security threat to the U.S. on our steel and aluminum exports to their market. We've had a fairly balanced trade with the U.S., particularly in steel. We happen to produce more aluminum than they do, but we've exported that without any kind of difficulty for many years. We are not a backdoor for subsidized steel coming from other countries like China and others, and we've been a loyal trading partner and have worked closely with the U.S. On protecting the North American market. So from our perspective, there was no way we could accept an outcome in the context of a free trade negotiation where we would have national security tariffs applied against our steel and aluminum. So we made it very clear early on in those discussions that we could not have a conclusion to this negotiation with those tariffs remaining in place. It was simply entirely inconsistent with a free trade agreement to have those tariffs in place. So we insisted that those had to be removed. To this point, we continue to be, along with Mexico, the only countries that really have any kind of exemption from those steel and aluminum tariffs. They are applied across the world to most other suppliers. Some have negotiated exemptions, but they paid for them in various ways. We have not. So this is steel and aluminum sector is something that's been a North American market, particularly between us and the U.S., for many, many years. We found it to be fundamentally unjust and insisted that they be removed before we completed this negotiation.
So, okay.
On to Mr. Lewis.
Well, thank you very much, and thank you very much, Mr. Verhoel, and to your team. It's going to be very interesting times, no doubt. Just a couple of questions with you, and I'm going to stay on the topic of steel and aluminum at this time. In the deal to remove steel tariffs, the U.S. can reimpose steel and aluminum tariffs if there is a meaningful surge of imports above historic levels. What defines meaningful, and was that discussed during negotiations?
Well, we did have discussions. There was no definition of what a meaningful surge would be. We have had a number of discussions at a technical level with U.S. authorities since the lifting of the tariffs on steel and aluminum. We've talked about the trade that's been occurring. We've talked about our pattern of exports to the U.S. And what that pattern looks like. And I think that it's safe to say that we have not been hearing expressions of concern from the U.S. I mean, in many ways, there was an artificial distortion introduced into the North American market. There was a bit of a rebound after that, which would be expected. But we have not heard any threats from the U.S. to reimpose those tariffs. And we, of course, would react very strongly if they were to consider that path.
Thank you. And supplementary to that, so the deal also limits how Canada can use retaliatory tariffs because we can only retaliate on steel and aluminum products. Mm-hmm. Traditionally, we would have retaliated with a broad range of tariffs that would strategically target specific sectors and legislatures. Mm-hmm. In your opinion, would we no longer be able to do that?
I think it would all depend on what the U.S., if they were to consider taking some kind of action against our steel and aluminum tariffs, if they were going to justify it on national security considerations as they did in the past. If we felt that those justifications were unjust, then I think clearly all bets are off. But we did agree to get removal of the tariffs, that we would monitor the trade going back and forth. The U.S., the biggest concern of the U.S. was any product coming in from outside of North America through Canada into the U.S. So we've been ensuring that we can demonstrate that we're not importing product from China or other countries around the world and transshipping that into the U.S. That was their fundamental concern. So I think as long as we can demonstrate that we're operating within a North American market, we don't have to get into those considerations.
Thank you for that. And final question, Madam Chair. I believe I have 2 minutes left. The new NAFTA has a complex series of rules for the auto rules of origin. Mm-hmm. These rules layer on top of one another and are complicated, and most industry analysis say that it'll raise the price of a North American car by thousands of dollars, particularly compared to a Honda or a Toyota. What economic impact analysis has the government conducted regarding the auto chapter, and can that analysis be provided to the committee?
We haven't done any kind of quantitative economic analysis, any kind of modeling of what that would mean. I think it's going to be something that we won't really start to see the impact until it comes, the rules come into effect. I think without a doubt, the rules of origin on autos are going to encourage further production within North America of both products, inputs to the auto sector, as well as the autos themselves. I think it's reasonable to assume that it may make North American built cars a little bit less competitive in other markets. But the whole thrust of these changes was to create more of a North American market where those products would be used within North America to the benefit of auto workers in Canada and the U.S. in particular, and in our various manufacturers that are producing these models.
Thank you very much. Thank you, Madam Chair.
Monsieur Verroul d'être ici parmi nous.
Thank you for being here. It's clear that the new CUSMA is a good thing for Canada and Canadian workers. However, I do have to point out that some of my colleagues on the other side of the House and on this side seem to be concerned about the impact of the agreement on the aluminum sector and workers in that sector in Quebec. So could you please explain the difference between the current situation and what we had, or rather what we will see under the new agreement? In particular, I would like to know how the new protections that you mentioned, the 70% that didn't exist before, how that will affect the sector, and how did we get to that outcome? What were the negotiations that took place?
In those negotiations on the rules of origin on trying to encourage and incentivize further production within North America. And when you take into account elements like the labor value content, in particular bringing production back to the U.S., and because we're in the same kind of category, back to Canada as well. Under the existing NAFTA, as you point out, there are no requirements whatsoever for the use of aluminum or steel, for that matter. The requirements were a very simple requirement that 62.5% of that auto had to be produced from products of North American origin. We now have a much more complex system that does have aluminum and steel-specific obligations contained in it. But I think at least as important as that is the fact that we've gone from this 62.5%, which exists in NAFTA, to 75%, not just on the vehicle, but also on the core parts, and also with the labor value content. So as we discussed a bit earlier, that leaves a pretty small margin for what you can bring in from offshore and have it as part of your originating content to meet those obligations. And as Martin pointed out too, there are certain elements, certain products in the production of a vehicle that are just simply not produced within North America, so that automatically takes up part of that room. You couple that with the fact that evolution in the auto sector is geared towards trying to produce lighter products, lighter cars. So that encourages the greater use of aluminum in things like engine blocks, other products, because it's lighter than steel and therefore more energy efficient. So we do feel that there's a significant incentives to use more aluminum than in the past. And again, if we do start to see aluminum coming in through the back door, in some cases, through Mexico, for example, we will be watching that very closely, and we have avenues to pursue that if necessary. I don't know, Martin, with you.
I mean, just to the latter part of your question about sort of the negotiating dynamic, I mean, Steve mentioned in his opening remarks that some of the American U.S. initial proposals were unorthodox, and that's very fair in the case of the rules of origin package that they initially presented. In addition to the 50% U.S. content requirement, they they had some ideas whereby you would need to know, for example, the origin of, say, the petroleum that was used to make plastics found in the vehicle, and similar things with respect to other metals and other materials. And when we spoke to the industry, they simply said, this goes to a question that was raised earlier about, keeping the industry competitive. And they simply said, these ideas were untenable, that it would, that amount of tracing or tracking of materials was just something they wouldn't undertake, especially in some instances we're talking about, getting a fairly small amount of preference, like a car entering the United States. It's only a 2.5% tariff. So there's only so much work, rules of origin compliance work that a company is prepared to do to save that 2.5%. So some of these ideas, like the 70% steel and aluminum requirements and some of the other things that are in there, were, I wouldn't say they were all Canadian ideas, but what we tried to do was move the negotiations in the direction of finding ways to incentivize the use of North American materials while not, completely undermining the competitiveness of the auto industry. We didn't want to, because, of course we want automakers to use as Canadian materials and Canadian parts, but we have to be mindful that they have to stay competitive and recognize that producers from outside of North America are not facing those same sorts of requirements. This is within NAFTA regime. So that's sort of how some of these ideas evolved.
Thank you very much. On to Mr. Savard-Tremblay for 2.5 minutes.
2.5 minutes. All right. I want to go to another topic, if we may. Of course, when we have talked about aluminum, and also supply management, but I want to talk about the environment. I know there is now a separate chapter on the environment. Does it set climate standards, air quality standards? Does it subject this agreement to international agreements, and are there sanctions under the agreement?
We made significant advancements when it came to environment with this agreement. Under the existing NAFTA, there is no chapter on environment. But we now, and it was in a side agreement, we now have a full chapter in the agreement. It is subject to dispute settlement, so we can take cases against it under the dispute settlement process that applies to the entire agreement. We do have a variety of new commitments that have been included on environment. So we have new commitments to address various global environmental challenges. Illegal wildlife trade, illegal fishing and depletion of fish stocks, species at risk, conservation of biological diversity, ozone depleting substances, marine pollution. First time in an environment chapter, commitments to improve air quality and combat marine litter. We've been...
Justement, si vous me permettez, la question...
If I may, the question I had is whether these are binding requirements or not.
If one of the other parties does not comply with the obligations, and I've just set out a number of them, but there are various others as well. If another party does not comply with these obligations, then we can pursue a dispute settlement case against them.
Mécanisme de règlement des différends.
My time is up, almost 30 seconds. Well, I don't have, it's hard to use 30 seconds very well. I would have liked to go, if I may.
Ah oui, parce que
Yeah,
il y a tellement de...
There are so many aspects in this agreement that I would like to raise.
Thank you. Under Chapter 32 of the agreement, it says that at least 3 months prior to commencing negotiations, Canada would notify the other parties, so the U.S. and Mexico, of its intention to commence free trade agreement negotiations with a non-market country, and that also no later than 30 days before a date of signature, we would forward the text of that agreement to our CUSMA partners. Given those provisions, is it not the case that as a matter of law, the U.S. and Mexican governments would have more right to information about a trade deal with China than the Parliament of Canada?
No, I would. My view would be absolutely not.
Does the government have a legal requirement to share the text with Parliament 30 days prior to signing the agreement?
No, but we do that as a matter of course.
Does the government have a requirement to consult Parliament at least 3 months before beginning negotiations?
I can assure you that if we were to engage in any negotiations with a non-market economy under the obligations of this agreement, such as they are, we would certainly be providing Canadians and Canadian parliamentarians with all of that information long before we.
There's no legal requirement to do that.
There would be no question that that would be provided.
But there is no legal requirement to do that. Is that correct?
There is it's not set out in the same terms because the terms of this provision are very specific. But I can assure you that.
And these terms are legally binding. Is that correct?
These terms are legally binding.
But there are no legally binding terms requiring similar disclosure to Parliament. Am I wrong? What would be the name of the act that imposes that obligation on the government?
I'm not aware of any specific act, but
me neither.
But there would not be any scenario that I can imagine where we would give any foreign country our obligations in an agreement or the results from an agreement to a foreign country in advance of giving them to Canadians, including to Canadian parliaments.
So would it make sense to have similar legal provisions ensuring that that information is delivered to Parliament and to Canadians at the same time or prior to delivering it to a foreign government?
Well, it's not certainly for us to say whether that needs to be a legal obligation or not. My only assurance I can give is that we would not be providing anything to a foreign entity prior to providing it to Canadians.
Thank you very much. On to Mr. Cram for 5 minutes.
Okay, well, thank you to all the witnesses for being here today and for all of your good work in the negotiation process. My question is about supply management. I had a meeting this morning with representatives from Sask Milk, and there seemed to be some confusion about the tariffs that are imposed if Canadian milk exports exceed a certain threshold. So I was wondering if you could clarify the export tariffs that Canadian dairy producers have to pay. Is that only for exports to the United States and Mexico, or is that to exports to the rest of the world?
Thank you, Chair. Thank you for the question. The provision that you're talking about, which applies to 3 specific dairy products that are set out in the agreement, covers Canada's exports of those products to all countries.
And is there a similar requirement under the old NAFTA?
There is not.
Are there similar requirements in the Trans-Pacific Partnership or the European Union trade deal or any other free trade agreement into which Canada has ever entered?
I'm aware of no similar provision in any of our other trade agreements.
So I was wondering if the negotiating team could give us some insight into how that particular requirement made it into the new NAFTA.
Certainly. Thank you, Chair, again, and thank you for the question. The provisions on affecting the dairy sector in Canada are designed to respond to specific interests and concerns as expressed by the United States during the course of the negotiations. In particular, the United States had expressed to us repeatedly throughout the negotiations concerns with respect to the market impact of dairy pricing changes that had been introduced in Canada in February of 2017 as part of the National Dairy Ingredient Strategy, whereby we established in Canada a new class of dairy products called Class 7 that had competitive pricing linked to international reference prices to, among other things, encourage investment in the dairy processing sector in Canada and to allow the sector to produce more innovative products. The United States had expressed concerns with respect to the impact that that change had in the first instance on the access into the Canadian market of certain types of dairy products, and then with respect to the possibility that Canadian exports of certain types of products that benefited from that new pricing class were displacing exports of American products from markets that they had traditionally exported to. We examined a number of ways of addressing those U.S. concerns through the course of the negotiations and ultimately determined that this was the least objectionable way forward.
All right, thank you. I also have some questions about the environmental standards that came up a little bit earlier in these meetings, and indeed earlier this week and last week in the House of Commons, some Liberal members made the statement that we do not want to have a race to the bottom when it comes to environmental standards. So I'm wondering, do the United States and Mexico, have they ratified the Paris Accord?
Well, I'm sure you're aware that the U.S. has not ratified the Paris Accord. Offhand, Mexico has ratified the Paris Accord.
So in my province of Saskatchewan, in the southern part of the province, there's what's known as the Bakken oil field, where half of this oil field is on the Canadian side of the border and half is on the American side. And as I'm sure you're aware, the federal government recently imposed a carbon tax on the province of Saskatchewan. So I'm wondering, are there any requirements in the new NAFTA for oil drilling operations in North Dakota or Montana to have to pay a carbon tax or similar fees the same way that is the case on the Canadian side of the border?
There are no specific requirements in that regard, although we do have provisions under the Environmental Cooperation Agreement that we would cooperate on various issues related to climate change, even though we did get a significant amount of resistance from the U.S. on issues related to climate change. But when it comes to many of the elements, including some of those that you're referring to, we do have this environmental cooperation agreement that obliges us to discuss these kinds of issues and try to find ways forward that we can both live with. But the issue of specific carbon taxes applying in a cross-border kind of fashion was not addressed.
All right.
All right. Mr. Sarai for 5 minutes.
Thank you, Mr. Verhal, and your team. You've done an amazing job and punched well above your weight dealing with a very powerful American regime that wanted a lot of changes, and we're very proud of the work that you and your team did. I come from a riding of Surrey Centre. It's got the highest softwood lumber employees, I think, in the province, I've been told. Softwood lumber has been an ongoing issue, and countervailing duties and agreements, and then agreements expire. When can we expect to reach true free trade in that? And does Chapter 19 still protect our interests and monitor and defends our interests in every trade dispute?
Yes, well, certainly softwood lumber has been a difficult issue between us and the U.S. for many, many years, as you're well aware. With respect to the existing NAFTA and the new NAFTA, the agreement stipulates that there is free trade between Canada and the U.S. on softwood lumber products. The U.S. has the right to pursue anti-dumping and countervailing duty investigations against imports from Canada, and they've done that frequently. That's within their rights. We have the right under Chapter 19 to challenge the way that they've done those investigations, and we have fairly consistently won those disputes because the U.S. has tended to, if not entirely break the rules, bend the rules fairly significantly from time to time in their calculations and in the way in which they proceed with those investigations, which is why we've won. So the preservation of Chapter 19, exactly as it is, from NAFTA into the new agreement is fundamental for us to be able to pursue those issues. We would like to negotiate an agreement whereby we don't have to go through this process all the time, but at this point, the U.S. has shown little interest in pursuing an agreement. You may be aware that the most recent administrative review on softwood lumber duties has demonstrated that the U.S. Department of Commerce has found much lower rates than are currently in place. We're hoping to see that after these preliminary rates have been published, that when we get to the final rates, they will indeed be lower and we'll be in a better position to try to get rid of these tariffs. So it's not a question of softwood lumber being outside of the agreement. It's very much a part of the agreement. It's just that the U.S. has been very exuberant in applying anti-dumping countervailing duties against Canadian exports.
Thank you. My next question is with respects to the new non-market country free trade agreements. If a CUSMA signatory other than Canada signs an FTA with a non-market country, what information would the government of Canada require, and what procedures would it use to assess the potential of the FTA on CUSMA, and vice versa? If we enter into an agreement with another country, what are the mechanisms that the other two signatories could impede that? What are their options, and what are our options?
Well, we do have certain obligations under that provision that if any of the three parties intends to enter into negotiations with a non-market economy, they are to notify the other two parties of that intention. They're also obliged to provide details of the outcome of that negotiation if they manage to complete it, and essentially keep the other two parties informed of the progress of that negotiation. If at the end of the day there is an agreement that's concluded, the other two parties could exercise their rights to withdraw from NAFTA if they saw fit. But I do want to emphasize that this is really no different than what exists right now. We would ordinarily inform trading partners such as the U.S. and Mexico if we were to enter into negotiations with another country, particularly a non-market economy. We would keep them informed. We have regular discussions with our trading partners, including the U.S. and Mexico, on our negotiations. And the right to withdraw from the agreement is a fundamental provision in every free trade agreement. Any one of the parties has to do is issue a 6-month notice that they would withdraw from the agreement. So there's nothing really new here. This was more of an issue of attaching further optics to the whole issue of negotiating with a non-market economy. That was a desire of the U.S., that they wanted to bring some profile to that. But fundamentally, it does not change our rights. It does not change our ability to negotiate with other negotiating parties. And this, I think, provision has been somewhat blown out of proportion.
Thank you very much. I'm sorry your time is up. On to Mr. Carey.
Thank you very much, Madam Chair. And I just wanted to go back a little bit about the cost-benefit analysis, or what we would call an economic impact study. And I just wanted to maybe through you to the minister how disappointed the opposition, I think unanimous, how disappointed we are that the minister didn't even commission a cost-benefit analysis or an economic study until a few weeks ago, particularly when, like the Americans, they finished theirs in April 2019. And, you know, we got about 3 inches of reading here that I think it would be beneficial if we were given that in advance. The American legislators and decision makers were given it before they had to debate it in their houses and their parliament and Senate. We're going to be given our cost-benefit analysis and economic impact study with the Canadian perspective after ratification. And if we have anything that comes up that needs amendment, we can't even really go back unless we send it back to the United States and Mexico. So that is concerning. The other thing is, when you mentioned the analysis, you said the minister is changing the parameters on the Canadian study so the minister can defend the agreement. Frankly, the minister needs to know we're not interested in giving the government an opportunity to necessarily defend the agreement. We want to know the truth and the impact that's going to be on Canadian industry. And my NDP colleague said quite eloquently with the steel or the aluminum questions, and he did so in the House as well. What is the status today for auto parts, for example, and what's it going to be in the future? So just a lack of transparency here and disappointment more than anything else. And I know she'll be here and maybe she can have an answer for us. But you guys know I'm from Oshawa, and we had really bad news that our plant wasn't given allocated new product. So even if I hear from the auto industry that they say they can live with the agreement, it's too late for my community. And what I'm worried about is the agreement puts on rules of origin that can be significant red tape. And my colleague asked about the cost on cars and things like that. My concern is we were heading down this road for North American integration, and for them to build a car here in North America, there is a tipping point. So the cost of a car here versus the cost of one of these manufacturers just making it offshore and then sending it over here, those costs and what that's going to do to the automotive sector, I think it's very important that we get that analysis. I'd really like to know from my constituents, because we certainly would like to see an agreement that, yes, if we're going to be having jobs moving north, so to speak, what is the advantage of investing in Canada versus investing in the United States? So I know, Martin, you've done a lot of work on this. And with this agreement, what's in this agreement that if I'm a General Motors, Chrysler, or a Ford decision maker, why am I going to put that plant in Canada versus the United States to keep jobs here?
Yeah, if I can just start.
A lot in that preamble.
There was quite a bit there, yes.
Yeah.
First of all, the minister Deputy Prime Minister has had no influence on this analysis. If I somehow gave that impression, I'd like to dispel it, because she has had no input or guidance or views on our economic analysis that is being conducted by the chief economist in the Department of Global Affairs without any kind of interference.
You did say, though, that the parameters for the Canadian perspective was being changed, and I appreciate you clarifying that, but it is under the government's role, basically, to take a look at those parameters so we can compare apples to apples and
that's right.
and things
and
like that. So
that's something that I have done.
Okay.
I think that if we want to look back, if we wanted to do the same kind of economic analysis that the U.S. did some time ago, we could do that very quickly. I don't think that's the kind of analysis that we really want to submit to parliamentarians to be able to judge an agreement on that basis, because we think there are fundamental flaws in that analysis. We are trying to do some analysis that's going to have more rigor, that will be more accurate in terms of the actual impact of the agreement. And I can assure you that you will not get the analysis after ratification has been completed. You will get the analysis within a matter of days. And that analysis will be the best that we can come up with at this point in time. And again, this is inherently a limited kind of analysis because we already essentially have free trade. And many of the benefits of this agreement are not elements that you can put into a quantitative model and get a result. So a lot of this has to be qualitative analysis inherently. But we will be providing that analysis to you in the very near future, and would be happy to defend it at any subsequent occasion.
Yeah, and we would like that as quickly as we can, because we just want to do the best job for Canadians at this table.
Thank you very much, Mr. Carey. On to Mr. Dhaliwal.
Thank you, Madam Chair, and thank you to you, Assistant Deputy Minister Steve Verhaal, and your team. And I want to thank you for the great work that you've done in the previous Parliament, and and welcome you back on this committee again. When I was doing the doorsteps, we recently went through the election. Every worker that I came across in Surrey Newton, every small to medium-sized business that I came across, they all wanted to get this deal done, and the majority of them, were predictability and stability. Could you please elaborate how this is going to help? When it comes to small and medium-sized businesses, not only in Surrey Newton, in fact, across British Columbia, because when I see, Business Council is supporting it, Labour Congress is, Canadian Labour Congress is supporting, and premiers. So what is in this deal that it will help British Columbia SMEs?
Well, thank you for the question, and I think that this has been one of the major objectives we had throughout the negotiations, was to try to improve this agreement, modernize it in ways that it would become more relevant and more accessible to small and medium-sized businesses. I'll give you one example. We have all these tariff preferences, duty-free trade into the U.S. as it stands now under NAFTA. The utilization of those preferential rates is about 50%. Part of the reason for that is that if you want to claim a NAFTA preference, you have to fill out a form, fax it into customs, and I'm not sure how many small businesses even still have fax machines, and you have to provide extensive amounts of documentation. Under the new agreement, you don't have to do any of that. You can simply send in your product. The actual bill going along with it can justify that it is of North American origin. We've streamlined the border. We've simplified all of the red tape that currently exists so that small and medium-sized businesses can take advantage of this agreement, whereas before they may have been hesitant to go through the process of filling out a number of forms, that kind of thing. We also have for the first time, a chapter on small and medium-sized businesses that's dedicated towards trying to find ways to assist small and medium-sized businesses to access foreign markets, to make it as easy as possible, because many small businesses are going to be content with trying to serve the domestic market and may be hesitant to start looking at foreign markets. We're trying to make that as easy as possible so that they can start to expand into other markets, and in particular the U.S., which is a common avenue that many small businesses work towards. So in addition to that, we've tried to address the regulatory barriers that exist so that they don't have to face those going into other markets, and in particular the U.S. So this is a very kind of, I think, unrecognized area of the work that we did on this agreement. It was very much below the radar because the U.S. wasn't particularly interested in this. But we've managed to streamline both the process of putting goods back and forth across the barrier, reducing those barriers that are beyond the border, regulatory, technical barriers, and I think that's where we'll see the greatest gains over time.
And when it comes to small businesses, you mentioned, it helps small businesses. And I see a trend that, more and more women are getting involved in running the small businesses. And how is this particular agreement will help those small business women to pursue to further?
Well, that has been a particular focus that we've been engaged in as well on the gender side. We do have a chapter related to gender. We've included gender provisions in the chapter on small and medium-sized businesses. We've included gender in other areas as well, including, remind me, it's the investment chapter, the labor chapter, and kind of inserted that throughout various of the provisions within the agreement to encourage women to be able to participate and effectively contribute to more economic access into the U.S. market and the Mexican market, for that matter.
It's
Time is up.
thank you.
On to Mr. Savard Tremblay for 2.5 minutes.
Là, je vais essayer de respecter mon.
I'll try to stay within my time frame. I would also like to talk about Chapter 28, best regulatory practices. It says that the policies adopted have to encourage trade and investments. That seems rather demanding because the rules have to be published yearly. That is the rules for the following year. It says that the data and approaches will be made public, and the problems that are targeted as well, and the other possible solutions. It seems to me that this will burden the machinery, and it will make it hard to actually liberalize our trade. Congratulations for getting rid of Chapter 11, but it seems to me that this is another chapter that is quite dangerous for sovereignty and parliamentary control.
When we look at the good regulatory practices chapter, when we look at the various annexes to the technical barriers to trade chapter, all of the efforts that we've made on the regulatory issues, all of this is about cooperation. There are not obligations. There's nothing in those chapters that say one must adopt this U.S. regulation or that U.S. regulation. It's about agreeing to good regulatory practices involving transparency so that the other country understands what the requirements are to enter their market. So small businesses can be very aware of what is necessary to sell to the U.S., for example. And all of this is oriented around cooperation to try to ease any kind of difficulties going back and forth across the border, not to put up any further barriers, while respecting our regulatory freedom to establish the regulations that we want within a Canadian perspective. It doesn't mean that we're looking towards harmonizing regulations. It means that we're looking at making sure that we can recognize each other's requirements and companies can prepare their products in such a way so that they can enter those markets. So this is all about trying to streamline movement back and forth across the borders, not to impose any additional barriers. In fact, the reverse, to remove barriers.
Thank you very much. Mr. Blake.
Thank you very much. After the first iteration of the deal was concluded, we heard that Canada's work was done. We had the best deal we could get. Democrats in the States successfully pushed to have the deal reopened. I'm wondering at that time, did Canada propose any changes? In particular, I'm wondering if Canada brought a proposal to the table around the August 1st beginning of the dairy year and whether or not the coming into force of those provisions could be held back until August 1st, and was that declined? Was the offer made?
Well, first of all, I may ask Aaron to elaborate on some elements on that latter part, but when the U.S. Democrats in the House of Representatives started to engage with the U.S. Trade Representative, we were very much part of those conversations, and we had a window into that. We were talking to U.S. Trade Representative's office. We were talking to some extent to the Democrats. And if you find, if you look closely at the provisions that are in the agreement that was reached to modify the original agreement reached on December 10th, when it comes to the provisions in relation to dispute settlement, when it comes to the provisions in relation to environment, in relation to labor, most of these were Canadian proposals that were made.
Did Canada make any of its own proposals in the second round of negotiation?
Didn't really have a need to, given that the Democrats were taking many of the proposals we made in the negotiations and picking them up as their own proposals.
So in your opinion, it was not an opportunity to try and, for instance, delay the coming into force of the dairy provisions by several months in order to provide some predictability to dairy farmers in this fiscal year?
That specific issue was not something that anybody on the U.S. side had any interest in, so that to my knowledge, was not pursued. I don't know, Aaron, if you have anything to add to that.
No, just to say that the dairy outcome overall was a very carefully and delicately put together balance of concessions and obligations. Given that there were not additional U.S. requests that fell into the area of Canadian agriculture as part of the protocol, we did not consider that we would seek any changes to the outcome that we achieved at the negotiating table.
Thank you. Do you have a little more time?
On to Mr. Fast.
Thank you. How many free trade agreements does Canada have?
Well, it depends on how you count them to some
extent. How many countries does Canada have free trade agreements with?
Well,
51?
I would say 51 or 53.
All right.
Somewhere in that range, yes.
Okay. How many foreign investment promotion and protection agreements does Canada have?
I'm guessing a bit here, but I think it's in the range of 30 to 35. I don't know if anybody can.
Yeah.
14 free trade agreements with 51 countries. So we have that.
All right. We've got all those free trade agreements. We have all those FIPAs, as they're known. And virtually all of them have some sort of investor-state dispute settlement in them, correct?
Yeah, correct.
So now we have a renegotiation with Donald Trump after we've had years of Canada being a champion of ISDS because it protects Canadian companies when they have a dispute with respect to a foreign country changing the rules, acting in a discriminatory manner.
Right.
And now suddenly we get to the new NAFTA, and Canada says, oh, we got to get rid of the ISDS. And wow, we've got a great win because we got rid of something that we've always championed. Can you explain to me that dynamic?
I can. When we look at investor-state dispute settlement, where that is of most value is with countries where we have limited faith in their court systems and with their ability to enforce agreements. So we have investor-state dispute settlement with many Latin American countries. We have investor-state dispute settlement with some African countries, various Asian countries. And we've got a lot around the world. We tend to have less of an emphasis when we are dealing with countries that have established court systems where there's a respect for the rule of law, and we don't feel that same kind of threat. But when it comes to the U.S., if I can just add, we have had the experience through the course of NAFTA where we have been challenged by U.S. investors, as I mentioned, many times. We have had cases where Canadian investors did try to make moves towards challenging the U.S. The U.S. has had no cases against us. That simply wasn't working as an instrument between us and the U.S.
Okay, but the reality is eliminating ISDS, the Chapter 11, effectively means that Canadian companies now have to find their resort in the American court system, correct?
Well, we also have investment obligations that we've agreed to that can be pursued state to state. So
that's right.
Yes.
But for a state to engage on that requires typically something more than just a company being aggrieved. I think states are reluctant to take up one company's case. It certainly was my experience when I was in the trade role. But I'm just surprised that suddenly we've said, well, you know what? We had ISDS there. We felt it was important back when we negotiated the original Canada-U.S. Free Trade Agreement, which morphed into NAFTA. Chapter 11 stayed there. And suddenly Canada is of a different mind that we suddenly trust Donald Trump and the court system in the United States. You understand my difficulty. Let me follow up with another question, and that is this. It's already been mentioned that we have an obligation to present any trade agreement with a non-market economy to the United States and Mexico if we want to sign one. So basically, we're coming cap in hand to the United States, to Donald Trump, and saying, please, maybe sign a trade agreement with China. Now, the United States has an obligation going the other way, except they've already signed a managed trade agreement with China, at least phase one. So they no longer have to come to us, cap in hand, to ask us to review that agreement and ask for permission. I find that disturbing simply because I'm not aware of any other trade agreement that Canada has signed where we've agreed to those kinds of provisions, that we actually cede our sovereignty to two other countries to determine whether we can negotiate a free trade agreement with a country like China. Doesn't that concern you?
It doesn't actually, because I think, first of all, the new NAFTA is not yet in effect. So the agreement, this phase one agreement that the U.S. has reached with China, is not something that we could pursue, even if we wanted to, because the agreement's not into effect
That's
yet.
my point.
Neither, if we started to negotiate an agreement with China right now, the U.S. would have no avenue to pursue us because the agreement's not in effect. But I think the most important element of all this comes down to the recourse. And the recourse is simply reflecting an element, a provision in the agreement that already exists. You can withdraw from the agreement with 6 months' notice. So if the U.S. does something that we don't like, we can withdraw with 6 months' notice. If we do something the U.S. doesn't like, they can withdraw with 6 months' notice. This is primarily an optical issue that the U.S. insisted on because of their preoccupation with the notion of a non-market economy. The notion of a non-market economy doesn't really exist in Canada or in Mexico. We don't use those terms. But the U.S. was preoccupied with this issue. But it changes none of our legal obligations. It constrains us in no way from pursuing an FTA with a so-called non-market economy. So I don't think that there's a fundamental change in the way things work now with this provision.
Okay. Thank you very much. On to Ms. Benayan, please, for 5 minutes.
Thank you. The first question that my colleague opposite, Mr. Carey, raised was with respect to amendments. Should the opposition parties raise proposed amendments to this agreement, would we risk losing some of the hard-fought gains that you've described over the course of the last 2 hours and others? And can you speak to some of the risks that this would entail?
Well, if on the Canadian side we were to propose new changes to the agreement, then that would mean that we would have to re-enter a negotiation, reopen the negotiations with the U.S. and with Mexico to see if we could reestablish a balance of concessions on the basis of a new proposal put forward by us. When the U.S. proposed to modify the agreement, following their discussions with the Democrats in the House and the agreement that was reached between USTR and those Democrats, they did have to come to both Canada and to Mexico to see whether we would be agreeable with those kinds of changes. We were part of those discussions. We agreed with those changes because they made the agreement better for us. So that was a fairly easy calculation. But if we were to make changes on this side, that would mean we would have to reopen negotiations. Part of the difficulty in our current circumstance is that, as we know, Mexico has already approved the agreement, the U.S. has already approved the agreement, and we're now in a situation where we are the last of the three parties to move towards ratification. The U.S., in its Statement of Administrative Action, has indicated that if a third party has not ratified the agreement, then they could proceed with the other party that has ratified the agreement. So in other words, they could proceed between the U.S. and Mexico, and Canada would be left out of that picture. So I think we are we do think it's strongly advisable that we move towards ratification as quickly as we can to preserve the gains that we have, to maintain our open access to the U.S. market and the Mexican market, and preserve NAFTA in its new form.
Thank you very much.
Mr. Cram.
Yes, thank you. I would like to finish my questions with the end of NAFTA, if I may, with the sunset clause that is now in being proposed in the new NAFTA. So I have heard from many stakeholders about the need for certainty in the marketplace, and indeed, my colleague Mr. Dollywell has talked about the need for predictability and stability in the marketplace. And I've also heard a few people in the media talk about how this deal will just get us through the Trump administration. This strikes me as a little bit short-sighted. You know, I don't have a crystal ball, but if you can imagine the year 2036, because I believe it is a 16-year sunset clause, if in the year 2036 the White House has an extremely protectionist president and they do not want to renew any NAFTA agreement with Canada or Mexico, does that mean NAFTA is done and that we have no more free trade agreement with the United States or Mexico?
Well, I think it's important to point out that none of these agreements are ever cast in stone. As I mentioned, there's a common element to almost all free trade agreements that you have the right to withdraw from the agreement with simply a 6-month notice. So this is not something that we can be assured will last indefinitely. And throughout the course of the history of NAFTA, the current NAFTA, over 25 years, we've modified NAFTA on many occasions. And we would expect going forward that we would continue to make modifications to ensure that the agreement is up to speed. What the U.S. originally proposed was a 6-year sunset after which the agreement would cease. We rejected that out of hand for exactly the same reasons you've identified, that would provide a high degree of insecurity for businesses that are relying on trading back and forth. We now have an outcome where there's a likelihood that you can have a 16-year assurance that the agreement is going to remain in effect.
Okay, but just to be clear, under the old NAFTA, a party had to take the initiative to withdraw from NAFTA on 6 months' notice, but under the new NAFTA, it expires. And the requirement to renew NAFTA is now on the shoulders of all three parties involved. Is that accurate?
There is a review at a 6-year period to determine whether or not the three parties feel that the agreement remains something that they want to continue with, and at that point they can extend it for a further 16 years. So this is more of a review than an opportunity to just simply remove a party from the agreement, although that remains always a possibility.
Okay, and Madam Chair, I would like to give my remaining time to my colleague, Colin Carey.
45 seconds or so.
I will be quick, Madam Chair. I'd like to move a motion relevant to today's discussions. Everyone around the table knows how important this study is and how we need to do it efficiently. So in the spirit of giving the agreement a fulsome study and to provide certainty. Oh, sure.
If it can be distributed, I think it's much more helpful.
Very wise.
You've supplied it here.
Mm-hmm.
Mr. Blakey, I'm sorry, we just started with this.
Yes. To speak to his motion.
Yes, sir. Yes, you are. No, this is in the middle of the witness's testimony. So Mr. Carey wants to read a motion into the record, and then at the completion, yes, and then at the completion, of him reading it into it. If he wants to, if we're going to have further discussion, do we want to maintain our witnesses here while we go through this? They had agreed to stay the additional 15 minutes that we were late in starting.
That, I guess it would be up to the witnesses.
Do we have any further questions for the witnesses?
We could discharge them if they would like. Yeah.
I'll maybe make a suggestion that
Sure.
you read into record what you want, which will
Sure.
be the end of your 5-minute area. We'll go to Mr. Aya for his 5 minutes left to enable to complete the clock.
All right. So it is in both official languages, but the motion, I'd like to move the motion that A, the chair of the committee write as promptly as possible to the chairs of the following standing committees to invite them to study the provisions of Bill C-4, an act to implement the agreement between Canada, the United States of America, and the United Mexican States, and the impacts within the respective mandates. 1, the Standing Committee on Agriculture and Agri-Food. 2, Standing Committee on Industry, Science, Technology. 3, the Standing Committee on Natural Resources. 4, the Standing Committee on Human Resources, Skills and Social Development and the Status of Persons with Disabilities. 5, the Standing Committee on Foreign Affairs and International Development. 6, the Standing Committee on Finance. B, for the standing committees listed in A, 1, recommendations, including any suggested amendments, be submitted in both official languages in relation to the provisions considered by them in a letter to the chair of the Standing Committee on International Trade in both official languages no later than 4 p.m. on Thursday, April the 2nd, 2020. 2, any amendments suggested pursuant to paragraph B1 shall be deemed to be proposed during the clause-by-clause consideration of BC4, and further provided that the members of the Standing Committee on International Trade may propose amendments notwithstanding the recommendations received pursuant to paragraph B1. 3, if a Standing Committee listed in A chooses not to consider the subject matter of the provisions, it advised the chair of the Standing Committee on International Trade by letter in both official languages no later than 4 p.m. on Thursday, February 27, 2020. And if in the spirit of getting this decided as soon as possible to provide certainty for the study, if we could vote on this today, I think that would be great.
Madam Chair, I would note that we've just received this, and in the spirit of collaboration and collegiality with which we started, I think on this side we would like an opportunity to review it. Secondly, I thought I heard my colleague mention the Standing Committee on Finance as a number 6 that doesn't appear in the copy that I have before me. So perhaps we could circulate a copy with the full motion as proposed by you, and perhaps we could also wait for our other colleague, Mr. Hoback, to join us from the trip that he's currently on in Africa with the minister, so that we can have the full committee look at this and vote at that time.
Yeah, there was the original copy. Mr. Carey did not have finance on it, and the one that you've given to the clerk now does. Hence be the confusion on the two. I have Mr. Blakey there, and then Mr. Dollywall.
Thank you, Madam Chair. I find the motion interesting. We're certainly concerned on this side to have a fulsome study of the agreement, but I haven't really had time to consider the motion. So I would move, Madam Chair, if it's in order, that we defer consideration of the motion to our next meeting during the second hour, immediately upon the conclusion of the minister's appearance.
And who do I have next? I have Mr. Dollywall.
Thank you, Madam Chair. And I totally agree with Mr. Blakey. Madam Chair, previous Parliament, Mr. Kerry was on the International Trade Committee and Mr. Sheen as well. And this committee worked very well between the NDP, Conservatives, and the Liberals. You know, we came up with the consensus on almost everything, and we were very productive committee when it came to doing things, whether it was here in Canada or when we were traveling abroad. And this is a great idea that we should park this, take some time to go over it, and then we vote on it. I appreciate that.
Mr. Tremblay.
I just want to point out that the problem isn't that the Senate Committee on Finance isn't here, but rather 3 and 4. Here we have international trade, and in French we have the Finance Committee. So I just want to be clear that things need to be the same in both languages.
There has been a suggestion that we hold this down at this time until everyone's had an opportunity. I'm sorry, before I go to I have to go to Mr. Fast and then to Mr. Blakey.
Well, the suggestion has been made, Madam Chair, that we defer this to next meeting when Mr. Hoback is back. I won't be here. He'll be back in his chair. I think that's a reasonable request to make. We want to make sure that this is a collaborative committee. It's an important study that we're doing, and I think if we can all get on side with this, it'd be helpful. So I'm open to that.
Thank you.
Sure my colleagues are as well.
Right. Mr. Blakey?
Thank you. Just a question of clarification. I suppose I had attempted to move a deferral with a particular condition, and I'm just wondering if we're discussing that and if we'll vote on that motion. Because I would, if the motion's in order, I would prefer just to have a vote on that.
Yeah, Mr. Dollywall.
So Blakey, it seems like we have consensus on the conservative and that side and this side. So I don't think there's any need to vote on this motion, and that we carry on with the witnesses and park it.
Everyone's in agreement, then we will defer the motion from Mr. Carey
To our next meeting.
until our next
after
meeting.
the minister.
After the minister?
That's what I had moved. So that's what that's why I'm just trying to be clear on what we're agreeing to. Yeah.
You're saying in the second hour. Okay, everybody's in agreement? Terrific. Okay. Now, we've used up all of the last few minutes. Can I go back to you, Stephen, and maybe you have some last comments that you would like to make in our 2 minutes that we have left?
Fire
up. Okay, we'll do that next.
Well, I don't think I have a lot to say at this point in time. I think I just emphasize that we rely heavily, with respect to the Canadian economy, on our access to the U.S. market in particular. Some 70% plus of our exports go to the U.S. I think that if we are going to be in a position where we do not have a functioning trade agreement between the U.S. and Mexico, that would be a significant hit on our economy. In my own view, we have a very a strengthened agreement in relation to what we have now, and we have security of access that is, I think, something to be highly valued. So I would hope that we would give that careful consideration moving forward.
Thank you all very much. Appreciate your time today and all that you've done for all of us up till now. So thank you very much. Meeting adjourned.